Microphone when you're ready, and introduce yourself, please.
Good morning. My name is Katie Powers.
All right, and if you will spell that for the court reporter, please.
Sure. It's K-A-T-I-E-P-O-W-E-R-S.
And Professor, are you a lawyer?
I am.
Are you a member of the State Bar of Georgia?
I am. I've been a member since 2009.
Can you give us your educational background, please?
Sure. I went to Georgia State undergrad, where I received my degree in political science. Once I graduated there, I went to Mercer Law School, where I received my law degree.
While you were at Mercer Law School, did you receive any awards or engage in any extracurricular activities?
I did. I was graduated in the top 10% of my class, was a member of the law review, the moot court board, as well as the mock trial board, and received faculty awards for different courses.
When you were a part of moot court and mock trial, did you win any championships or receive any awards for those?
We did. We were national champions.
After you graduated with your law degree, can you begin with your educational background, please?
Sure. When I graduated, took the bar exam, and then began with the Clayton County DA's office on August the 3rd of 2009.
What position did you have with the Clayton County District Attorney's Office?
When I began, I was an assistant district attorney. I was there for 7.5 years and remained as the executive chief assistant district attorney for about 4 or 5 years.
When you were the executive chief assistant district attorney, did you have any roles in prosecuting cases in that capacity?
Sure. I was in charge of our major crimes division, which was the homicide unit, public corruption, and anything else that the district attorney assigned to me during that time. I tried approximately over 75 felonies, about 2/3 of those were murders.
And what kind of murders were you prosecuting?
Homicide cases that varied from child deaths to multi-co-defendant homicides, anything really that came in the office.
In your capacity with public corruption, did you conduct any investigations into public officials?
We did. I was part of a 3-person team that conducted a special purpose grand jury investigation and prosecution into numerous county officials that included the sheriff as well as mayors in Clayton County as part of a public corruption investigation.
And as a result of that public corruption investigation, did you all obtain indictments against some people?
Yes, the special purpose grand jury made recommendations. They were presented to a subsequent grand jury that indicted several public officials as a result of those investigations, of that investigation, rather.
Now, after you finished with the Clayton County District Attorney's Office, what did you do next professionally?
I was appointed to the state court bench and served as a state court judge for a year, from January 3rd of 2017 to January 3rd of 2018, where I was appointed as a superior court judge and served in that capacity.
But beginning with your state court judgeship and going into your superior court judgeship, in addition to those judgeships, did you sit on any boards that you were appointed to?
Yes, I sat on the Georgia Commission on Family Violence, as well as served as some roles in the administrative office of the courts that dealt with additional judgeships, things of that nature.
Currently, and after you became a superior court judge, what did you do after you were a superior court judge?
I got to go home to Mercer Law School, where I'm currently a professor of law and director of trial advocacy there.
At the same time that you are a professor of law and director of trial advocacy, do you have any other professional jobs that you do as well?
I do. I am appointed by the Georgia Supreme Court as a special master on bar discipline. So when bar disciplinary cases come in, I sit and hear those as it relates to the violation of the Georgia Rules of Professional Conduct or Standards. I also serve on the MARTA Board of Directors as a representative for Clayton County, and as well as the Board of Department of Juvenile Justice, which is not just the Department of Juvenile Justice. We also serve as the Board of Education for the Department of Juvenile Justice as well.
Let's take those one at a time. You said that you're a special master with the Georgia Bar. Kind of give us a better idea of what that is.
Sure, there are 20 of us throughout the state of Georgia. We're appointed by the Supreme Court and assigned cases on a rotating basis. When a complaint comes into the state bar, there's a procedure, and if it's elevated to one of us, then we conduct a hearing on that matter and determine discipline as it relates to the lawyer that is then reviewed by the Supreme Court. That can range from anything from disbarment of the lawyer to public reprimand to private reprimand to other remedies as well.
Do you have any specialized training that goes along with doing that?
Yes, I had to conduct I had to receive training to become a special master before completing my appointment that involved training from various lawyers as well as the State Bar of Georgia, and as well as the Supreme Court Justice.
And I think you touched on this, but I want to ask you again, who appoints you to be a special master for the State Bar?
It is an order by the Georgia Supreme Court.
And how many special masters are there in the entire state of Georgia?
There are 20 of us.
So, let's back up a little bit. You sit on a board involving juvenile justice.
Yes.
What is that?
It is the State Board of Juvenile Justice. We work in conjunction with the commissioner for, there are various juvenile detention facilities throughout the state. We work with the commissioner as it relates to those facilities, rehabilitation procedures within those facilities, as well as the educational part. It's actually the largest educational district in the state because of the amount it is, and to make sure that the juveniles who are in state custody for whatever period of time don't miss an educational gap as well. So we work in conjunction with the commissioner as well as the State Board of Education.
And in your capacity as a professor, do you have to teach students about ethics?
Yes, that is one of the main things that at the law school, along with my specific courses, are courses on trial practice, advanced evidence, and advanced writing, as well as the supervision of all of the moot court mock trial teams that are at the law school.
And in your capacity as a prosecutor for, I think you said 7 or 8 years, did you have to abide by prosecutorial ethics when you were there as well?
Yes, not only did we have to abide by prosecutorial ethics, I supervised an office of almost 70 individuals. We received, as lawyers, annual training of an ethics and CLE that was put on by the Prosecuting Attorneys Council of Georgia. That's the large body that kind of puts on our training each year and gives us our continuing legal education credits that we're required to get each year. Part of that is ethics.
And I think you just touched on something. You have ongoing training involving ethics when it comes to the State Bar of Georgia, being a lawyer, being a special master, all of that sort of stuff.
Yes, it is a yearly requirement.
Here at this time, we would tender Professor Powers as an expert in the area of prosecutorial ethics.
Any voir dire or objection? She shall be so qualified.
Thank you very much. Professor, did you review the case file involving District Attorney Mark Jones?
I did.
And do you recall approximately when you were provided that?
I believe it was either in early October or the end of September. My report was October the 13th.
And like you just indicated, did you create a report?
I did. I created a report after reviewing the materials provided to me by you that reflected my findings.
I want to begin with a body cam that has already been admitted into evidence involving Corporal Sherman case. Did you review that?
I did.
Tell us your initial observations when it comes to the video.
Well, I was asked to review the video. I viewed it in its entirety and made notes specifically as it related to statements. It was my understanding, based on my review of the case file, that the corporal was a witness in a proceeding that was upcoming. And I made notes about various statements that were made to that corporal as it related to his testimony.
All right. Now, when it comes to the corporal and it comes to being a prosecutor, are you allowed, when you're outside the office, if you are not working, can you go up to a police officer and ask them to perjure themselves?
No.
Now, as a prosecutor, can you go up to a police officer and can you tell them to testify to something that is not true?
Absolutely not.
And why is that?
Well, for several reasons. Number one, the law that's established that you cannot suborn perjury, along with you have an ethical duty to deliver and represent the state of Georgia that is your client and deliver justice and only present the evidence and facts that you have before them. You're not allowed to invent them, massage them, or change them.
Now, you talked about something a moment ago, and I want to back up a little bit about prosecutors. Do prosecutors have clients?
The prosecutor has one client, state of Georgia.
And what is their duty
To uphold and seek justice. A lot of times, folks sometimes will believe that prosecutor's job is, solely to represent victims of crimes. And while that's one part of it, it's also to represent the state and the taxpayers that they've either been duly elected to represent or are representing those taxpayers as an assistant district attorney.
And when you talk about that duty of justice, are there times in a prosecutor's job, I should say, where a victim may not agree with the prosecutor?
Absolutely, that happens a lot of times. I wouldn't be able to put a percentage on it, but it certainly is not an isolated incident.
So when a prosecutor doesn't agree with the victim, does the prosecutor have to do what the victim says?
No, absolutely not. The duty of the prosecutor is to render, and I keep going back to this term justice, but it's really so core to what the duties are, that that's certainly what the prosecutor represents.
So what happens if, in terms of whether the district attorney can prosecute a case, well, let me back up, let me ask this a different way. If the victim disagrees with what the prosecutor is doing, does that necessarily cause a conflict?
No, not in the legal sense of a conflict. It certainly might cause a conflict between the prosecutor and the person, the victim, or the victim's family or friends who are bringing that issue to the prosecutor. So it might cause a conflict in the English sense of the word, but certainly not in the legal sense.
So let's kind of break that down a little bit. You talk about the English sense of the word. What do you mean by that?
I mean, just in your common understanding of what a conflict is, whether it's a conflict with my spouse, my coworkers. You have arguments, you have disagreements. Those might be termed conflicts, but those are not what the rules or the law states is the legal conflict.
So what are you talking about when you talk about a legal conflict?
A legal conflict is defined both by the statutory authority, so both by the law as well as by the State Bar of Georgia professional rules of conduct that talks about a relationship, if you will, that would create a conflict. Are you close? Is it a close family member? For instance, one of my family members had a burglary occur at their home when I was a prosecutor, and we had to disqualify the entire office because that would be an improper relationship that would cause that type of a conflict.
So you use the word disqualification. When a conflict occurs, does the entire district attorney's office have to disqualify?
Depending on what the conflict is, typically that would lead to the disqualification of the office. Rarely, if at all, as an entire office not disqualified.
So, are you familiar with the statute involving conflicts?
I am.
All right. Have you reviewed that statute in preparation for your testimony?
I have.
Now, did you listen to the 30-minute phone call between Mr. Jones and a gentleman named Chris Bailey?
I did.
Did you hear anything in that phone call about Mr. Jones saying that if they weren't on the same page, then Mr. Jones would have a conflict?
I did hear this.
What is your professional opinion as to whether that constitutes the conflict for Mr. Jones?
It is my professional opinion that that did not rise to the level of a conflict in either the legal sense or in the ethical sense. At no point was there any disclosure of any pecuniary or business interest or monetary interest that the two might have shared or not have shared, or any close personal relationship that would have led to those conflicts. The statute spells it out pretty clearly, and we adhere to that. And to really hold otherwise would require the district attorney's offices throughout the state are disqualified every time someone's unhappy with their decision.
And in your experience, how many disqualifications of district attorney's offices would that cause every year if a victim just disagreed with the prosecutor?
I mean, hundreds of thousands probably. I mean, it depends on the case load, but certainly there have been numerous either victims or victims' families who initially either at one point in the proceeding or throughout all of it have been displeased sometimes with what prosecutors do. And that doesn't rise to the level of a conflict.
So, listening to the recording, what that portion of the conversation, in your professional opinion, from a prosecutorial standpoint, is a district attorney allowed to tell someone that there's a conflict, so I'm going to get out if you don't withdraw your motion?
No, and I'd like to back up for a moment. The motion, part of what I based my opinion on, was the motion that the third party filed.
Mr. Bailey, right?
Mr. Bailey, Mr. Chris Bailey. And the motion that he filed, we have a crime victims bill of rights here in Georgia. And what was filed as a third party with the judge. And had that proceeding gone forward, a judge would have made the determination about what happened. The district attorney, at that point, would have just been a party who was at the table. Notably, even every time someone files that under the Crimes Victims Bill of Rights, it doesn't disqualify the district attorney.
And you talk about the Crime Victims Bill of Rights. Is there also a constitutional right to be heard in court for victims?
Yes.
And if that motion is filed, like the one that Chris Bailey filed, do they have both the statutory and constitutional right to be heard in court?
Yes.
And can you threaten someone to withdraw that motion?
Absolutely not. Nor can you promise them anything to withdraw that motion.
Did you hear anything in the recording that in your professional opinion, in your professional prosecutorial ethics opinion, would have rose to a level of threat?
Yes, several statements. I need to know that you're 100% behind me. If you're not, we may have to find someone else. I need to know that there's no division. We can't show any division in court. Were a couple of the statements. Along with, if you look at it from the context, even Mr. Bailey asked, well, are you saying that if I don't withdraw this motion, you're not going to present this case back to the grand jury? At no point was there a renunciation, or did Mr. Jones withdraw any of his statements in talking about that? In fact, he talked about getting a separate, specific lawyer.
Who was that separate? Was it that John Reagan? Was that the name?
John Reagan was the name on the recording that I listened to, yes.
And do you know where he's employed?
He's employed with the Prosecuting Attorney's Council of Georgia, not with the Attorney General's office.
All right. And based on that employment, does Mr. Reagan work in the Chattanooga Judicial Circuit?
No, it's not.
Okay. So when Mr. Jones, you recall a portion in the call when Mr. Jones says that he's going to pick John Reagan.
Yes, he did, which again caused me to have concern.
Why?
Specifically, as we are trained as lawyers and as prosecutors, if you have a conflict, you're certainly not allowed to then pick who takes over. That defeats the purpose of you having a conflict. The law requires that when you have a conflict, you're to notify the Attorney General's office, and then the Attorney General's office assigns conflict counsel for that. It's no different than if you have a conflict with a private client and then have to withdraw. You don't then get to pick subsequent representation.
When you're a prosecutor, if you tell, I'm sorry, I'm backing up. Listening to the recording, did you hear any sort of statement about, I'm the best friend you got?
Yes, I did.
Can you tell us the context in which you heard that?
When speaking about whether or not Mr. Bailey should continue with his motion, Mr. Jones, in context, also said, well, I'm the best friend you got, while explaining that if there's a conflict, that he would have to be removed from the case.
And as a prosecutor, can you do that?
Absolutely not.
What's the problem with that?
Well, if you've got a conflict, the moment you have one, you're to notify everyone you have a conflict, and then you stop the conversation. It's not a promise or a threat to withdraw a motion, or it would be akin to Mr. Bailey had threatened to go to the media, and these statements were made along those lines. It's simply just not appropriate.
I want to shift gears a little bit to talk about the oath of office for a prosecutor. Are you familiar with it?
I am. I take it every 4 years.
Fair enough. Are you familiar with the portion that says that you shall only take your lawful compensation?
I am.
What does that mean?
It means you're only to take the lawful compensation as allowed to you, and essentially your salary, what you're paid out every year by the county government, or by the state, depending on if you're a state employee.
Can you sit on a board?
You can certainly sit on a board, but you cannot receive compensation. So I could not have served on the board of directors, if you will, because I could not have received a separate compensation for holding that job, in addition to being a prosecutor or an assistant DA.
Now, are you allowed to volunteer for things?
Absolutely.
For example, when you were a prosecutor, did you volunteer for something?
Then I coached the Jonesboro High School mock trial for 17 years.
All right.
I'm going to ask you not to do the math on that.
Fair. So when you are a prosecutor, what about offering money for convictions? Can someone offer money to get a conviction?
No.
Why not?
Well, number one, it would be a violation of the oath of office, receiving only lawful compensation. It's an incentive-based offer of either a monetary reward, along with the fact the oath indicates that you are not the holder of any unaccounted for public funds. Public funds, depending on the source of that money, that would certainly be a violation of the oath of office of either the district attorney or assistant district attorney, both of those ones.
Now, in your expert opinion, could that create some sort of perverse incentive?
Yes, of course, it certainly creates a conflict, but instead of, I'll go back to what we were talking about, prosecutors or ministers of justice. So instead of, for instance, an assistant DA bargaining a case or dismissing a case, when there wasn't enough evidence or enough witnesses is what your duty is. Certainly, if you're being offered for money for convictions, it disincentivizes the very thing the prosecutors are supposed to do, they're the gatekeepers.
What about in terms of plea bargaining, say from a murder charge?
Certainly an offer of payment in exchange for a conviction, as opposed to plea bargaining for a murder charge, is again a violation, would require the attorney to violate their oath of office for that. Certainly there are murder cases that a plea agreement is reached for whatever reason, whether it's based on lack of aggravating circumstances, or maybe there's some mitigation as it relates to the person charged with the crime. And if you go out and if I were to have offered my assistant district attorneys that I managed and supervised money for convictions, that certainly defeats the purpose of our office.
In the lawyer world, are prosecutors pay a lot of money?
No.
As a result of that, are monetary incentives be better for prosecutors if they can get them?
It certainly makes a difference. I knew what I made coming out of law school, which was substantially less than all of my colleagues, but thankfully it was the job I wanted to do and got to go back to my hometown. But certainly, when you're offering money to some of the lowest paid lawyers in our profession, that certainly causes a problem for incentive-based conviction.
Did you take a look at a text message between Shanika Terry and District Attorney Mark Jones?
I did.
And do you recall the nature of the text message?
I do. It was a promise of money or a conviction.
Was it a promise of $1,000 to get a murder conviction?
Yes.
And in your expert opinion, is that outside of lawful compensation?
Yes.
And is taking anything outside of lawful compensation a violation of the oath of office?
Yes, it's a violation of receiving money that is not lawful compensation, and depending on the source of that money, it could also be a violation of not holder of any unaccounted for public money.
So let me ask you a hypothetical. Let's say that was taken out of the that language there, or that was allowed. What would stop a district attorney from enriching themselves?
Absolutely not.
What if a district attorney made a rule that said, if I take one case, I'm going to get paid $150,000 every time I take one case?
That would be, without the language in the oath of office?
Without that language in the oath of office.
That would be completely problematic, and would probably bankrupt counties throughout this state. It's taxpayer dollars.
So, did you review a portion of an interview where Ms. Kimberly Schwartz was interviewed?
Yes.
And do you recall Ms. Schwartz discussing being offered money to announce ready for a trial?
Yes.
Now, is that similar to offering money for convictions, or is that different, offering money for convictions, in terms of violating the oath?
No, it's still receiving money that is not lawful compensation. Regardless of whether it's to present to a case to the grand jury, it would be the same as, I'll give you $1,000 to dismiss this case. It's incentive-based compensation. It's not part of the law of compensation.
So, announcing ready for trial, what could be a problem with announcing ready for trial when you're not ready for trial?
Well, a myriad. We used to tell our baby ADAs that if you weren't ready, it would be better to be yelled at by the judge than to not be fully prepared. Sometimes you might be missing witnesses. Sometimes you might not have all of the evidence that you need. Sometimes things might still be being tested at the GDI. So if you're not ready for trial, and you announce ready, and then you're called to trial, and you're missing all of this evidence, you're not fulfilling your duties in that matter.
You just talked about your baby ADAs. Do you mean the young prosecutors and new ones?
Right. We would call them younger baby ADAs because they were new and fresh faced, but and of course they wanted to do a good job, but we wanted to make sure that we were still fulfilling the mission of our office.
What about sort of the more experienced ADAs that may be prosecuting murder cases? Are the stakes a little bit higher on murder cases if you announce ready and you're not ready?
Absolutely.
What could happen?
Well, number one, you could have a not guilty verdict from the standpoint of the state. If you're announcing ready for trial on cases that aren't ready and you're not ready, certainly then you might result in a not guilty verdict. There might be evidence, perhaps if you haven't fully looked at your evidence. An example would be a search of a cell phone. If a search of the cell phone hasn't been done, the prosecutor doesn't know what's on there. There might be things that help the prosecutor, or there might be things that help the defendant, which you're required to turn over. And if you haven't gone through all of that, then it can cause a problem.
Let me shift gears a little bit. Are you familiar generally with the sentencing schemes in the state of Georgia?
I am.
Okay. Involuntary manslaughter, how is that punished in the state of Georgia?
I believe it's a 1 to 10.
And voluntary manslaughter, what is that punishable by?
I believe that's a 1 to 20.
And how about malice murder and felony murder?
Punishable by life.
Okay. Now you say punishable by life. Are there two different kinds of life in the state of Georgia?
Sure, there's life in prison with the possibility of parole, and there's life without the possibility of parole.
Well, let's start with the latter one there. Life without parole. Is that sort of self-defining?
Yes.
Okay. Life with parole. How long do you spend in prison on that?
Typically it was 30 years prior to any change.
And when you talk about 30 years, is it 30 years and then you're released?
No, it's 30 years, I'm sorry, before you're even eligible for consideration by the parole board.
Would it be easier to say 30 to life on that?
Yes.
Even on a life with parole sentence, is it possible you're just never released?
It is possible.
And is there one other sentencing scheme in the state of Georgia when it comes to murder? Is the death penalty possible?
Oh, yes.
Okay, all right. And I want to take you all the way back to what we talked about in the beginning, the video with Corporal Hayes. Do you remember it?
Yes.
At one point in the video, do you remember Mr. Jones, say, discussing with Corporal Hayes how a charge of involuntary manslaughter is, and I'm sorry to use this language, I'm talking about video, when he says it's weak shit.
I do recall that.
Is that problematic?
It was problematic, especially in context of the statement of how are we supposed to get a plea if he's not indicted for murder.
What's problematic about that?
As prosecutors, we're only to charge the evidence that is supported by probable cause. You're not supposed to charge things just so you can go and reduce it to garner a plea bargain.
So let's say someone is indicted for murder. When the proper charge is involuntary manslaughter, what kind of pressure does that put on a defendant, from a defendant's standpoint, to accept a plea of involuntary manslaughter?
Well, it certainly looks different from a state's perspective for a defendant. If you're facing something of 30 to life versus a possibility of 10 years, that certainly puts pressure to resolve the case. And that's why the rules, along with the Georgia Rules of Professional Conduct, which also apply to prosecutors, 3.8 is pretty clear. As is the law, you're only to charge what you have probable cause.
And even if you don't have probable cause for it, if you were to ask someone to lie under oath, could that get you a probable cause?
I mean, if you require them to lie under oath to facts that would support the charge that you are seeking certainly that would help you get to probable cause where it did not exist before.
Now, you said you watched the video. Did you see any portion where District Attorney Jones asked Corporal Hayes to testify about Elijah Farrell's relationship with Sarah Cole?
Did.
Can you tell us about your initial thought on that?
When the statement was, why can't you just say he thought she was cheating on him? And then Corporal responded with, because there was no evidence of that, that's not the evidence. And Mr. Jones continued to say, well, are you going to back me up or not? The victim's family calls me every day, and texts me every day, I believe. I think it was an indication of both methods of communication. Are you going to back me up or not? Why can't you just say that? And the corporal continued to say, because there's not evidence.
Now, are you going to back me up on that? In an indictment like that, is it about backing up the prosecutor?
No, it's about whether or not you have probable cause to pursue the indictment.
And what what would be the appropriate thing for a prosecutor to do in that instance?
Well, in that instance, it would be to present the evidence that was already presented, supported the charge.
Out there, but the police officer doesn't know about it. Can you go ask the police officer, hey, I need you to say this without any evidentiary backing that the police officer knows about?
No,
What's problematic about that?
because you're asking them to change their testimony based on the evidence that only they had without looking at further evidence. You haven't said, hey, I want you to look at these set of pictures. Do you still hold this opinion? It was just, you should say X, Y, and Z. It was not that.
Because what would happen if the prosecutor, even after looking at that evidence, said, well, I still don't change my mind. I still don't agree with you. Is that a possibility?
Absolutely.
And so does that kind of go to what the problem with the video is?
Yes.
Now, Professor, your expert opinion, based upon your experience, your job as a special master with the bar, former prosecutor, former judge, and current professor, is offering a prosecutor money for a conviction, a violation of the oath of office.
Yes.
And in your expert opinion, based upon all of that, your professional experience, is it ethically appropriate for a prosecutor to ask an officer to lie under oath?
No.
Is it appropriate to ask an officer to testify to something that they don't know about?
No.
Is it appropriate for a prosecutor to ask an officer to testify to evidence that they have not shown the officer?
No, it's not.
And in your expert opinion, is it appropriate for a district attorney or a prosecutor to tell a victim to withdraw a motion or they're going to conflict off the case?
Absolutely not. That would be just totally ignoring the crime victims' bill of rights, along with the rules and the law that applies.
And does that place the victim between a rock and a hard place?
Yes.
How about Mr. Bailey's position? Does that put him between a rock and a hard place based upon what he was told by Mr. Jones?
Yes.
How so?
Essentially, it's does he have a shot at the district attorney listening to what his family had expressed and representing this case to the grand jury, or should he just have to withdraw his motion and not be heard about the fact he was not notified about any of his rights to be heard?
Did Mr. Jones ever present any sort of option where Mr. Jones was still on the case and Mr. Bailey got to go forward on his motion?
No.
And is it the duty of the prosecutor?
Sorry.
And is it the duty of the prosecutor to tell a victim the options that are out there, whether they're good, bad, or ugly?
Yes.
And should Mr. Jones have told, in your expert opinion, should Mr. Jones have told Mr. Bailey that this is not a conflict, and if you want to talk about it in court, you're allowed to talk about it in court?
Yes.
Even if it's good, Mr. Bailey's opinion is good, bad, or ugly?
That's right.
Your Honor, I have nothing further for this witness.
Ms. Wright, she's with you.
Thank you, Your Honor.
Good morning, Ms. Howard.
Good morning.
My name is Attorney Tony Wright, and I represent Mr. Jones.
All right.
Now, you don't know Mr. Jones, do you?
I do not.
You've never spoken with him.
No.
In fact, you've never spoken with him about any of the evidence that you reviewed concerning any of his statements.
No, because he, as a witness from the state, he certainly has a constitutional right not to talk to me.
Absolutely, you know that because you're a lawyer.
Right.
But you did know Mr. Fowler before you got hired for this case.
I did, yes ma'am.
In
I
fact, you and Mr. Fowler worked together at the Clayton County DA's office, isn't that true?
did. Yes, when he was in charge of crimes against women and children.
And was he your boss at that point in time?
No, I was his boss.
You were his boss?
Yes ma'am.
Okay. And you've never been elected as a district attorney in any circuit, have you?
No, ma'am.
In fact, have you ever run for district attorney?
No.
Since you're a lawyer, you're aware that there's a difference between things that are unethical, maybe unprofessional, and things that are criminal.
Yes. Sometimes they're both.
But not always.
Not always, but sometimes they are.
Concerning Mr. Jones' statement that he believed the victim was cheating on him, you agree that Mr. Jones is allowed to have his own opinion about the evidence as he sees it?
Yes, that he believed, that Mr. Farrell believed that the victim was cheating on him. Is that when you said he, I just want to make sure we're talking about Mr. Farrell?
Yeah, we're talking about the statements concerning the Farrell case, because that's what the nature of that video of Mr. Hayes was about.
Right, I just want to make sure I understood who you were saying when you said he. Thank you.
And prosecutors and officers sometimes disagree.
Yes, ma'am.
That's not unusual.
No, it's not, as to the disagreement.
You also mentioned that the statement in your report that the family texts me and calls me every day. You took issue with that.
I did in the context of Mr. Jones's intent, when he was continuing to encourage the people about what he should say. He used that in context of saying, you should say this, they text me and call me every day. That's not an evidentiary reason to change testimony. Yes, ma'am.
And so you're using that to make the argument that that was in fact Mr. Jones' intent, to change testimony.
No, I'm using Mr. Jones's statement that he should change his testimony. That statement just corroborates his intent. I mean, it's not solely.
Now, you agree with me that victims in cases are often concerned about how the case proceeds.
Yes, ma'am.
And the state of Georgia has gone so far to give victims a Bill of Rights.
Yes, ma'am.
And so DAs are charged with speaking with victims
Yes.
and addressing their concerns.
Yes.
And you agree that ultimately Mr. Jones had the ultimate decision when it comes to what someone's charged with?
He has the ultimate decision when it comes to what someone is charged with within the bounds of the law, if it's supported by probable cause,
And the evidence.
which would be the probable cause, yes, ma'am.
And that's because Mr. Jones is an attorney that's going to be the one to look at all the evidence and actually present it in court. Would that be accurate?
Yes, if he's the one who is going to present it, yes, ma'am, or one of his ADAs, certainly.
And since you never spoke to Mr. Jones, you don't really know what evidence he reviewed outside of what Sherman Hayes said in this video. You have no idea, do you?
No, ma'am, I do not. I also know, though, that he did not reference any external evidence when telling Corporal Hayes that he needed to adjust his testimony.
Did you see Mr. Jones with a case file there on the sidewalk of the hooch?
No, ma'am.
Do you think that he was in a position to cite to an official record of evidence while they were having this sidebar conversation outside the hooch?
Well, I don't know what his position was. He seemed pretty firm in the fact that he was receiving calls and that the corporal should change his testimony. I don't know what his position was as to what he remembered or
Right.
what he knew at that point.
And you agree you don't know because you never spoke to Mr. Jones to get clarity?
No, ma'am, as he was represented by counsel, I certainly would not have called him at that point.
Of course. But a lot of what you're saying are just assumptions about your perception of what you thought or think Mr. Jones meant.
No, ma'am, not his statement that you need to change your testimony and the corporal's statement that the evidence was not there to support it. That's based on my direct observation of it.
Are you aware that Sherman Hayes testified that there was phone dump evidence and social media evidence that he admits he never reviewed in detail?
I did not review any of Sherman Hayes' testimony.
And if you did have knowledge that Sherman Hayes had not reviewed specific evidence in this case that perhaps Mr. Jones had, that would change your opinion about the basis for Mr. Jones making the statements to Sherman Hayes, wouldn't it?
No, ma'am, not when he said you should change it and the corporal said the evidence didn't support it. And then there was no reference to anything else with, well, let's revisit this conversation when I think you said it was phone dump evidence. When you look at the phone dump evidence, or I have a case file, let's revisit the conversation. Instead, the statement was, getting called every day. How are we going to get a plea when it's not charged with murder? So no, ma'am, that was a reference. So it wouldn't change my opinion based on Mr. Jones' statements.
It wouldn't change your opinion that Sherman Hayes had not reviewed critical evidence in this case that may have supported the statements being made by Mr. Jones? That
Objection
didn't change
assumes
your
facts,
opinion?
not evidence. Also mischaracterization of the evidence.
Your Honor, Sherman Hayes testified that there was
Judge,
evidence.
we're going to talk about testimony in open court. We need to approach.
All right, well, let me see y'all up here. What specifically Corporal Hayes did or did not testify to in this regard. Ms. Wright, you can go ahead.
Ms. Powers, let me ask it this way. Hypothetically speaking, if you were aware that Sherman Hayes had not reviewed critical evidence in this case, that perhaps Mr. Jones had reviewed, which laid the basis for Mr. Jones' statements, would you still hold the position that Mr. Jones' statements to Sherman Hayes were given to him to influence him to perjure himself?
Yes, ma'am, because the statement that was made about changing the testimony within a company, how are we supposed to get a plea when there's essentially not a higher charge, and the fact that his phone was ringing daily. And there was no reference to those statements at the time of you need to change your testimony.
Now, Sherman Hayes said that he didn't need to be called, that Mr. Jones didn't need him to testify falsely in order to support what he wanted to charge him with. That's true, right?
Yes, absolutely.
And
Present conflicting evidence all the time.
absolutely. And Mr. Jones could bring this evidence and present it to the grand jury, and he didn't need Sherman Hayes, did he?
I don't know what he needed or what he did not for the case totally, but so I don't know whether or not he would be needed in the case entirely, because I haven't heard that.
And you know what? That's my point, Ms. Powers. You don't know because you don't know all the facts, do you?
What I do know are the facts that were presented to me in Mr. Jones' statement. Yes, ma'am.
And you have made a stance that you believe Mr. Hayes over Mr. Jones.
No, I believe Mr. Jones, based on the words that he said, that you need to change your testimony. It was not a credibility determination. I looked at both of their statements.
Did you have an opportunity to review the indictment?
Yes, ma'am.
I noticed in your report that you do not make any reference to an opinion about what lawful compensation is in your report.
Not in the context of my report, no ma'am, but I did review the oaths of office.
But don't you think that if this is a question of whether or not these witnesses were receiving unlawful compensation, that it would be important for you as an expert to include in your report a definition?
No ma'am, I think lawful compensation is pretty self-explanatory in the concept of salary.
Well, if it was pretty self-explanatory, why are you here to testify?
I don't know, I've been subpoenaed, and so I came down to offer my expert opinion.
And you've been here to offer your expert opinion on behalf of the state, correct?
Yes ma'am, that was the individual who subpoenaed me to testify.
Now, you're not saying that a DA can't give a raise to an assistant DA based on performance?
No, typically those go through the county commissioners that approve those, and normally, it's for lack of a better term, we go through and do an evaluation every year that's required by the county, and then the county commissioners either sign off on the increase in pay or not. Or if you're a state employee, it's a step, but everything's structured.
Have you made salary decisions within the district attorney's office in your past?
I have. We have two types of assistant DAs in our office. They're either what are called state paid ADAs, which are allocated by the state, as well as county paid ADAs. And there were certain structures. If we wanted to amend that structure or add what's called a step, if you will, for salary, we would put a proposal. It would be voted upon by the county commission. It would go through HR, and then we would request the specific employee be placed into that role. Yes, ma'am.
Are you aware that in Columbus Consolidated Government, there is no county commission?
Well, whatever the county government is, no ma'am. I mean, we went through the Clayton County Commissioner's office from my experience.
And you would agree with me that just because something happens that way in Clayton County, it may not happen that way everywhere, like in this county.
No, but the laws are pretty universal. And for our state paid ADAs, it's the same concept of waiting to go, having to go up a step, having to have the requisite experience, and then making the request through the state. Yes, ma'am.
And because you're not so familiar with the Chattahoochee circuit, are you aware or ever been made aware that in this county there are salary supplements that are issued to assistant ADAs?
Right, and the supplements are no different than compensation from the other bases. The supplements, as written and required, and are also governed by, we have supplements as well, that are governed by rules and how they're allocated. Yes, ma'am.
And those supplements are paid on a monthly basis?
Depending on the jurisdiction, it can be either monthly or it can be bi-weekly.
Okay, but it's not like a lump sum payment?
No, ma'am.
Now, in your review of the evidence concerning statements made by Ms. Terry and Ms. Schwartz, you understand that neither of those women ever got clarity on what Ms. Jones meant when he said something about $1,000 payment.
I don't know what their state of mind was. All I know is what I observed from the interview as well as the text, which was an offer for payment.
And you're not aware that had Ms. Terry or Ms. Schwartz inquired further that those $1,000 payments would have been made over the course of 12 months like their salary?
Objection. Assumes facts, not evidence.
Objection sustained.
Ms. Powers, this is not the same thing as saying, dismiss a case and I'll give you $1,000. You made that statement, but that's not what we're talking about here because nobody in this case got any money for doing anything. That's true, right?
I don't know whether or not the receipt of money was made. That was not the basis in my opinion. The basis in my opinion is that when the offer of money is made, that is what occurs and that is what is inappropriate, and it would be no different than an offer of money to dismiss a case. So I would disagree and say it is the same.
Now, you would agree with me that Mr. Jones, as a district attorney, has some discretion with respect to salary raises?
He has discretion with respect to salary raises, which are lawful compensation, not based upon random offers of payment for certain duties.
Random offers of payment, right?
Right.
They were random.
I don't know whether or not they were random or not, or if this was repeated behavior.
You just testified that they were random, so I'm just going, you read the facts and evidence, right?
I don't know whether or not they were random or repeated behavior. I just know that the two that I saw were, in my professional opinion, not legal.
You would agree with me that if there were more of these statements out there, that the state would have provided those to you to review?
I don't know. I would assume so, yes, ma'am.
Because that would have been important, right?
Yes, ma'am.
Have you ever been made aware that after Ms. Schwartz alleges that she heard that Mr. Jones wanted to offer her $1,000 for a murder conviction, she did in fact get that murder conviction on the case that she is now claiming was not ready for trial? Did anybody ever make you aware of that?
No, ma'am. The focus of my opinion was what was legal within the context of bribery and violation of the oath of office, not the outcome of the event.
And Ms. Schwartz actually got that murder conviction that she says that she was unprepared for in 30 minutes. Were you aware of that?
Objection. Assumes facts, not evidence.
I'm moving on, Your Honor. Your report concerning the bribery charges, there are 3 counts, 4, 5, and 6.
Yes, ma'am.
Your report is about a paragraph long.
Yes, ma'am. I thought it was about that straightforward.
Because mainly it's just your opinion about your thoughts about the evidence of the case.
No, ma'am. I would state that it's based on the oath of office that every ADA takes, along with the evidence that was cited. And so there was not a lot to walk through based on that offer of payment that was not lawful compensation.
Now, you were a lawyer, Ms. Powers, and you will agree with me that in the law, we deal with statutes and case law.
Yes, ma'am.
Now, absent from your report, are any statutes or case law to support any of your positions? Isn't that true?
No, there's OCGA, it starts with a 15, along with the Crime Victims Bill of Rights. I believe that's on page 3.
Got it. Okay, so
As well. But no, I didn't include any case law because that's not relevant to the basis of an expert opinion here.
but did you review any case law in formulating your opinions?
No, ma'am, that's certainly up to the judge.
Okay. So these are just kind of off the cuff, your thoughts, you just jotted them down in this report?
No, ma'am, I wouldn't consider it off the cuff. It's based on my over 10 years of experience as a prosecutor, a judge, and now I'm a professor.
And you do research in all of those capacities?
Yes, ma'am.
But you didn't include any of the research that you did for this important case in your report, did you?
That's incorrect. On the first page of my report, I list the materials that I reviewed and looked at, and then based my opinion on that. They're enumerated. It's on page 1.
Okay, materials reviewed. Again, Ms. Powers, I don't see any cases or statutes here listed in the materials you reviewed.
The statutes are on page 3, if you'd like to turn it back. There are no cases that are listed in them that's within the purview of the judge as it relates to, or counsel's argument. It's not relevant to my expert opinion. I was looking at the statutes and case law along with the indictment and the materials of the report.
So you included statutes for some of the charges because page 3 that you keep referencing deals with only with Chris Bailey.
That's correct. It's a statute on disqualification of a district attorney, along with the statute that references the Crime Victims' Bill of Rights. Yes, ma'am.
Right. There's a statute on robbery.
Yes, ma'am, and it is included in the indictment that I reviewed, which is listed on page 1 of our report.
And there is a statute on subordination of perjury.
Yes, ma'am, which is listed in the indictment that I reviewed, which is listed on page 1 of my report. It's also listed in the count heading for that.
Are you saying that the statute is listed in the indictment?
No, I'm saying that the count that defines what the Bribery Act is listed in the indictment. As you know, robbery can be performed in a variety of ways, but my opinion is only relevant to the question of whether it was performed in a specific manner, in a specific way, for this specific case.
Right, but what I'm trying to get you to at least hear me out here. I understand that there is reference to the bribery statute in the indictment, but did you reference it in your report?
No, ma'am.
And did you reference any statutes concerning the subordination of perjury?
Not the specific statute in my report, but familiar with it.
But you could have, because you cited a statute in the sections concerning counts 8 and 9 dealing with Chris Bailey.
Correct, but the two statutes that are cited in counts 8 and 9 explain counts 8 and 9. They're not what, they don't form the basis of the charge, if you will. It talks about the law and the background of it and why it's different.
Let's talk about counts 8 and 9, because you spent 2 or 3 pages talking about that particular count and just a couple of paragraphs on all the other counts. You said that there was...
Questioning him.
Objections overruled. Go ahead, Ms. Wright.
You said that there is no evidence that Mr. Jones was disqualified from interest, but you agree with me that whether or not someone is disqualified from interest is a matter for the Attorney General to decide.
That's correct. Once the reasons are placed into a letter to the Attorney General, and the reasons as stated do not rise to the level of disqualification, yes, ma'am.
Now, wouldn't you agree that, and you talked about baby DAs, you would agree that Mr. Jones is like a baby DA in this situation, and a newly elected DA has any concern about whether or not a conflict exists or not, in an abundance of caution, he should proceed as if a conflict does. Wouldn't you agree that that would be a safe way to play it? You weren't sure?
Let me answer your questions in turn. I would not characterize Mr. Jones as a baby DA. When I'm talking about the baby lawyers, I'm talking about ones who are newly graduated from law school, not with many years of experience.
Well, weren't you meaning that new baby DAs, I think you said they were new prosecutors.
Right.
Prosecutors that had not been prosecutors before.
Right. I would also consider them brand new lawyers. No one who's an experienced lawyer is coming out taking a brand new prosecutor's salary 10 years after practice. So a baby DA I refer to as essentially one of my students who have recently graduated and been employed.
And the exception to that would be a newly elected DA who'd never been a prosecutor before.
No, if that person had been a lawyer for many years, the statutes are the same whether or not you're defending them or prosecuting them.
I'm not talking about the statutes. We're talking now about whether or not Mr. Jones would be considered a baby DA because he's never been a prosecutor before. You would agree that that would be a factor as far as Mr. Jones being cautious about proceeding when posed with a potential conflict?
No, ma'am, because what I reviewed does not appear to be caution. If it was caution, then the conversation potentially would have been.
Now, you don't have any evidence of whether or not Mr. Jones did in fact contact the AG's office?
No, ma'am, I do not.
And in your report, you agreed and you started off the first paragraph talking about how you understand that Mr. Bailey doesn't even have standing under the statute that he wrote.
He does not have standing to be a party to the proceeding. He does have what's called third-party standing, which means that he has the right to be heard in court if he feels like he's not been notified about any proceeding that he was required, that he, I apologize for using the pronoun, that Mr. Jones was required or his office to notify him by law. So no, he would not have standing for the criminal case as far as being a party, but he would be able to be heard as it relates to his motion.
Now, the motion that he was talking about, he brought because he alleged that he had missed a hearing.
Those were the statements that I heard yesterday.
Now, I know you weren't here for Mr. Bailey's testimony. Have you had an opportunity to review it? He testified yesterday.
No, ma'am, my understanding is that I was under the rule of sequestration, so I certainly have not reviewed any witness testimony.
Fair enough, fair enough. So Mr. Bailey testified that he was acting alone and solely on his own behalf when he filed that motion. Were you aware of that? No?
I've just stated that I was under the rule of sequestration, which prohibits me from talking or discussing anybody else's testimony. It would be a violation of my ethical duty.
All right. Mr. Bailey also testified that Mr. Jones never asked him to withdraw his complaint. And you're not aware of that either.
All I know is the reporting that I was provided.
Right. And your report is based off of information that came out prior to this trial.
Yes, ma'am, that was the evidence that I was provided to review.
Now, wouldn't you agree that it's an important fact that Mr. Bailey acknowledges that Mr. Jones never asked him to withdraw that complaint?
I don't believe in the reporting. I heard Mr. Bailey acknowledge that he never asked him to withdraw the complaint. I heard Mr. Bailey say, are you saying that if I don't withdraw this, that you're not going to present it to the jury?
And Mr. Jones' response was, no, no, no. Do you remember that?
I do.
You would agree with me that Mr. Jones has a duty to the state and not a victim?
Yes, ma'am.
That Mr. Jones doesn't represent a victim?
Absolutely.
And that it would be improper for Mr. Jones to be advising the victims of the law and their rights as if he did represent the victim?
No, ma'am. There is a crime victims bill of rights that outlines the duties of the district attorney and his office and what the office as well as the district attorney and his or her representatives are required to do. So, no, ma'am. It would also, so that would, to advise them about their rights under the crime victims bill of rights, it is a duty.
Now, Mr. Bailey in the report said that he was frustrated because he had been calling the DA's office and not getting information.
Yes, ma'am.
And that he somehow figured out how to file this because as he was calling, nobody would tell him how to exercise his rights under the law.
Yes, ma'am.
And that's because when someone calls like the DA's office, you can't give legal advice, can you?
No, ma'am, you cannot give legal advice, but there are representatives, either assistant DAs, or what's called victim services, who advise individuals about their rights under the crime victims bill of rights that's required.
You testified that you were aware of a statement concerning John Reagan with Pat.
Yes, ma'am, I heard that.
Were you aware that at the time Mr. Jones made that statement about John Reagan, that he in fact had an office in this building?
No, ma'am, it doesn't change my opinion though, because you can't pick the lawyer once you allegedly have a conflict.
Fine, that decision would ultimately not be up to Mr. Jones, it would be in the purview of the Attorney General, Chris Carter.
Yes, ma'am.
Now, you stated that monetary incentives is a policy question, presents some policy issues.
I don't know that it presents a policy issue. It's not appropriate when you're given only your lawful compensation.
And, you know, this whole notion of lawful compensation, again, you don't include a definition of that in this report that you put together.
No, ma'am.
You said that what Mr. Jones said as far as a conflict was not appropriate.
It was not correct, as well as not appropriate, yes, ma'am.
But you didn't say it was against the law.
No, ma'am, convincing in the context, the statement about the conflict in and of itself is not against the law, but in context of, I need to know that you're fully behind me, that we can't show division, as well as withdrawing emotion and statements about that in its total context. It is my expert opinion that that was unlawful.
And even though Mr. Bailey testifies that Mr. Jones never told him to withdraw his complaint, you pieced all these different pieces together to draw that conclusion.
No, ma'am, I haven't pieced them together. I've listened to the audio tape in its entirety and based my opinion based on the audio tape in its entirety.
And you would agree that if you did, and I understand you're under the rule of sequestration, but if you did have the ability to review Chris Bailey's testimony, there may be facts that came out in trial that could change some of your opinions in this report.
As it relates to the audio statement, no, ma'am.
I'm just asking if it's a possibility. Is that a yes or no? That could, if there were facts that you don't have, that Chris Bailey testified, that could change your report, yes or no?
Yes, if it relates to the audio statement itself and the date alleged in the indictment. I was only charged with looking at the conduct on that day and the audio recording on that day. I was told that the audio recording itself was complete.
And so if Mr. Bailey testified to something different than what's in the audio recording, you wouldn't have that information, and therefore the basis of your report could be affected.
I mean, not the basis of my report is to the audio recording. I know what I've heard. And so the basis of my report is simply as it relates to the statements on the audio recording. I can't tell you what anyone else testified.
As an expert witness, Ms. Powers, you get paid to come to court and give your opinion.
No, ma'am, I'm receiving no compensation.
Oh, so you're here for free?
Well, I mean, it cost me some gas money to get down here.
Okay. So you're just here to do Mr. Fowler a favor?
No, ma'am, I'm here to render my expert opinion as it relates to ethics. I'm charged with training lawyers in this profession. I'm charged with supervising lawyers in this profession. And I know what it looks like for prosecutorial ethics. I'm here to give my opinion.
And you mentioned that you're on a lot of state boards in this state.
Just two.
Just two.
Yes, ma'am.
And are you appointed to those boards?
I'm appointed to one by my county and to another by the state. Yes, ma'am.
Okay. And so you're just here to help the state today?
No, ma'am. I'm here to render my opinion about what's ethical and what's not based on my long-standing experience.
But you are here as a state's witness.
I've been subpoenaed by the state. I would have answered your phone call had you given me one too.
And you would agree that you were asked to put this report together by the state?
I'm required under the rules of discovery if I'm going to enter an expert opinion to prepare, write, and provide a report as to my findings. So that's what the law requires me to do, yes, ma'am.
And just like you agreed to help Mr. Fowler out today, you could have said no.
I could have said no. I was asked to render an expert opinion as to my opinions. It could have been that the conduct was lawful. I wasn't told what my opinion needed to be, just to review and to offer an expert opinion, which I did.
All right, thank you, Ms. Powers.
Thank you.
Anything else for this witness, Mr. Fowler?
Yes, I want to correct the premise of something. You were asked multiple times whether you spoke to Mr. Jones. Do you recall being asked that?
I do.
Can you tell us the problem with that?
When someone is charged with a crime, certainly they have a right against self-incrimination. Also, it's inappropriate to call when someone is represented by counsel to request an opinion. It's no different than an investigator attempting to get a statement from a defendant after being represented by counsel and called for trial. It's simply not allowed.
If you had called Mr. Jones and gotten facts about this case as a member of the bar, would that have been ethical for you to do?
It would have called into question my law license.
Could you have been disbarred for that?
Yes.
I have nothing further, Judge.
Just to
Anything else?
redirect Your Honor. Ms. Powers, now I understand Mr. Fowler's position and question concerning your inability to speak to Mr. Jones because of the position he's in. But you would agree with me that if you did have the ability to have a conversation with him to understand a little bit more in context what he meant by certain statements, that would be helpful to you.
No, ma'am, not in the context of risking my car license. No, ma'am.
Last question. You've been a prosecutor a long time,
For about 7.5 years, just now.
and you agree that if someone commits, if someone is killed during the commission of a felony, that the charge could be felony murder.
You could support that, yes, ma'am.
Perfect. Thank you. No further questions.
May this witness be excused?
Yes.
Thank you, Ms. Powers, you're free to go. Ladies and gentlemen, we've been at it about an hour and a half.